Welcome back to West Virginia Gun Law. I'm attorney Todd Leneve. Today I've got breaking news for you regarding an interim final rule filed by the Department of Justice in which it removes all authority from the ATF in connection with background investigations for petitions to restore federal firearms rights. Stick around. 18 United States Code, Section 925C, is a federal law that's been on the books for decades and provides a path for citizens who have been disqualified from firearms use or possession or ownership because of a federal disqualifier, a path forward to petition in the federal courts for restoration of their Second Amendment rights. Now, many decades ago, the U.S. Attorney General, through authority that was granted to it through federal law, delegated the responsibility for conducting background checks to the ATF, with the reasoning that the ATF was in a better position to be able to conduct those kind of checks, advise the Attorney General, and then have the Attorney General be able to make its response to the petition. So over the years of ATF doing this kind of work, they noted that there was a big budgetary strain on their agency because of the manpower and time investments that were involved in conducting these kind of background checks. When the issue was addressed in Congress in 1992 passed an amendment to the law that basically said that the ATF and the Department of Justice could no longer receive budgetary funding for these types of background checks. So in effect, what that 1992 law did was eliminated the effect of 18 U.S.C. 925C, the section that provided for restoration of rights. And so essentially, it killed any ability for a citizen who had lost their firearms rights to petition in the federal courts to be able to get those rights back. Now again, this is distinct from state-level convictions or state-level disqualifiers. Those have always had a path forward in our state's courts. But when it came to a federal disqualifier, that's where this budget issue rose its head and took away the right. So, under the final rule that was passed today, not passed, but actually took effect today, the Department of Justice, under Attorney General Pam Bondi, essentially said, hey, effective as of today, we are rescinding the delegation of authority to the ATF to conduct these background checks. Now, unlike a lot of the final rules that we've discussed in the past on things like frames and receivers or the pistol brace rules, things like that have had to go through an extensive process, this rule is different. And within the rule itself, it explains why that's the case. Notice and comment is unnecessary because this is a rule of management or personnel, as well as a rule of agency organization, procedure, or practice. For the same reasons, this rule is not subject to a 30-day delay in effective date. So again, under this new interim final rule, the ATF no longer has any role in the process of investigating petitions for restoration of Second Amendment rights. Now, to be clear, this rule doesn't allow those petitions to be filed immediately, but it sort of spells out some framework, as we'll get into, as to how that may happen. But for now, the first step has been taken, which eliminates the ATF from consideration. So the rule goes on to explain the disqualification issue under federal law by making this statement. Federal law prohibits several categories of persons from possessing in or affecting commerce any firearm or ammunition By statute, it also provides that any person who is prohibited from possessing, shipping, transporting, or receiving firearms or ammunition may make application to the Attorney General for relief from that disability. Now, as I said, that relates to 18 U.S. Code Section 925C, which again has been in the federal law for decades and decades. Again, it hasn't been able to be used because of the funding issue, and the funding issue was because ATF couldn't handle the process in a financially sound manner, and Congress stepped in and said, all right, no more money gets to be used for that specific purpose. Well, under this rule now, AG Bondi has removed the ATF from that process altogether going forward. So why is this happening right now? In Executive Order 14206 of February 6, 2025, the Protecting Second Amendment Rights Order, the President directed that within 30 days of the date of this order, the Attorney General shall examine all orders, regulations, guidance, plans, international agreements, and other actions of executive departments and agencies to assess any ongoing infringements of the Second Amendment rights of our citizens. So President Trump campaigned on a very strong Second Amendment platform in this approach to the recent election, and that is being moved into action through these various executive orders. This one in particular tells AG Bondi that she's to look at everything that comes out of the regulatory state, which of course we see under attack right now, which it needs to be. We have too many agencies, too many regulations, too many rules, all imposed by bureaucrats who are not answerable to the voting public because they aren't voted into office. And so under this executive order, the President has told the Attorney General, I want you to look at everything that's been done through federal bureaucratic agencies, and if it impacts the Second Amendment, I want to know why, how, and what the plan is to take care of it. We don't want to see these infringements continue to happen. And so she was given 30 days. She has not met that 30-day standard in pretty much any capacity whatsoever. But the passage of this interim final rule does suggest that she's taking that mandate seriously, that she is working on these things to make changes that are going to better the Second Amendment community. But as part of this process, the rule does go on to clarify that, we're not just taking the ATF out, but there will be more to come. The department anticipates future actions, including rulemaking consistent with applicable law, to give full effect to 18 U.S. Code 925C, while simultaneously ensuring that violent or dangerous individuals remain disabled from lawfully acquiring firearms. So once again, this interim final rule doesn't clear the path immediately for citizens who have federal disqualifiers to petition in the federal courts, but it opens up the process by streamlining it, getting rid of what the problem has been all along, the ATF, thank you very much, and says, hey, we're going to put rules into effect in the near future that will make this process effective so that people who have a path forward under 925C can actually exercise that right to petition the courts for restoration of their Second Amendment rights. Let me know your thoughts on this one by dropping a comment in the comments section down below. Please share your ideas, questions, anything you have here. I think this is a great issue, and it is going to be one that going forward, sometime in hopefully the near future, we're going to be able to have folks who are disabled by federal law from owning a firearm being able to hire an attorney, petition the courts, and get those rights restored. We'll keep on top of this one because this is a huge development in Second Amendment protection. I appreciate you being here with me today. It's good to be back in front of you guys. I look forward to seeing you the next time around. Until then, take care and stay safe.